it pains me to give kudos and props to the government, but hey, credit where credit is due. When you do a good job, I'm going to tell you about it. And let's compare the very first paragraph that we just start to this one. These defendants were prepared to fight, not for their country, but against it.
Yeah.
In their own words, they were, quote, willing to die, end quote, in a, quote, guerrilla war, end quote, to achieve their goal of halting the transfer of power after the 2020 presidential election.
I mean, you can hear that in Morgan Freeman's voice. That's written so well.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. Hey everybody, Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. Guess what? Another current event, Elmer Stewart Rhodes, the of OathKeeper fame, of Arizona, an Arizona local boy, sentenced on Thursday, May 25th to 18 years, which to date is the longest sentence of any 1/6 defendant. But as we're going to talk about today, he's no ordinary defendant. It is time to do our world famous sentencing post-mortem on Elmer Stewart Rhodes and company, because some of the other Oath Keepers have been sentenced, some are awaiting sentencing, but we're going to break it down. We're going to break it down in three things today. One, how did the guidelines shake out? And guess what? We did. Mark Allenbaugh. Hi, Mark. By the way, special guest today, our returning champion, Mark Allenbaugh, of course, to talk about all this. Hi, Mark Allenbaugh.
Hello, Doug.
Welcome back. I guess I sound way too cheerful for a podcast with this dark material, because it really is such a dark, horrible, ugly chapter in the American story that is still ongoing and unfolding. So I'm going to take it down a notch. I guess I just shouldn't be this chipper, but I suppose maybe underlining my chipperness is the fact that you and I did a podcast on this many, many months ago, well before the case ever went to trial. It was actually one of the first podcast episodes we did together, and it was like a YouTube bonus. It was called the Sedition Edition, which I thought was very pithy, but where we made predictions.
Right.
And you said this is because this was a really uncharted waters. There's not even a guideline that exists for the big charge here, which was seditious conspiracy. So it was not an easy guideline calculation to do by any stretch of the means. And I guess why I'm feeling so chipper and so proud, and I really can't take any credit for this at all. It's all you, but you pretty much nailed everything, all of your predictions right on the head. And so I'm going to put the link to that episode in the show notes, because we really did do a deep dive there into all the relevant guideline provisions. So we may gloss over them a little bit more quickly in this, but if you guys are interested, go back to Sedition Edition. Scroll through the early, it's right at the beginning, and I'm putting a link in the show notes. So if you just go to www.setforsentencing.com and go to this page for this podcast, you'll get right there to Sedition Edition. But we're going to talk about the guidelines today, see how those shook out, and we're going to talk about the sentencing advocacy. How'd the lawyers do? How'd the government do? How'd the defense lawyers do? And lastly, we're going to talk about the BOP, the prison issues, because, like I said, 18 years, Mr. Rhodes is headed to prison for a very long time. So we would love to talk a little bit about where he might go and how much time he's actually going to serve and what that time might look like. So we got a few things to talk about. Let us dig in. We know that Elmer Stewart Rhodes did not plead guilty. He went to trial. So anyone playing following along at home, or who knows the system well, knows there's something that is often imposed, we like to affectionately call the trial penalty, which means if you're going to fight this out and maintain your innocence, and then you lose at trial and are convicted by a jury of your peers, by the time you get to sentencing, you're going to have some problems. You're not going to get the same kind of reductions and benefits of the doubt and acceptance of response, all that stuff. So this is where we pick up on our story. Elmer has been convicted at trial. He goes to sentencing, not repentant, not remorseful. In fact, he's called himself a political prisoner at sentencing and expressed zero remorse. The judge referred to him as, quote, an ongoing threat and a peril to this country and to the republic and to the very fabric of this democracy. So when a judge is talking like that, you need to brace yourself because you know severe sentence is coming. So talk to me, Mark Allenbaugh. What we know is 18 years, but how did we get there under the guideline calculation, real quick?
So yeah, as we spoke about in our in the sedition edition, there is no guideline for seditious conspiracy, so the court was directed to go to 2X1.1, which says go to the most analogous guideline. The most analogous guideline to seditious conspiracy is treason, which is 2M1.1. But that guideline says, unless it's the equivalent of war against the United States, go to the next most analogous guideline. And what the court chose here for all of the pretty much all of the J6 defendants, whether it was Rhodes all the way down to the misdemeanor folks, was the obstruction guideline, the obstruction of justice, 2J1.2. And then once we got there, once we got to that guideline, the way that guideline shut down, 2J1.2, you start at a base offense level 14. And then the court assigned an additional 8 levels for the offense, because the offense involved or caused or threatened to cause physical injury to another person. There was obvious physical injury. And by the way that enhancement is written, it's very important for many people to understand this. When it says the offense involved something, that doesn't mean that the defendant did something, or that the defendant had to have done something, just that the overall offense involved that. So even though somebody else may have caused injury to somebody, as long as that the defendant participated in that offense conduct, he's going to get hit with that with that enhancement. And that's correct, what you just outlined there. And so then, oddly enough, this next enhancement, which
so anybody who is math challenged like me, you start at a base offense level, which is 14. Right. Then this one, it gives you 8. So now we're at 22. Go ahead.
Right, 22. So the next enhancement, for those that can't see, actually has to do with international terrorism and being convicted of a 1001, which is a false statement, or a 1505 offense, which has to do with obstruction. Also, that didn't apply here, interestingly enough, even though we see the word terrorism, that enhancement actually didn't apply. So then we go down to substantial interference with the administration of justice. That gets you another 3. The court found that the offense conduct substantially interfered with the administration of justice. Congress had to shut down for several hours, and people had to run away. So that was substantial interference. And then finally, so now we're at a 25, or offense level 25. And now the last one has to do with if the offense involved destruction, alteration, or fabrication of a significant number of records or tangible objects. There was plenty of that going around, as we saw in the videos. And if any records were destroyed, that certainly occurred here too. And then finally, there's a catch-all if the offense was otherwise extensive in scope and planning, and we well know that it was very extensive in scope and planning. So you get another 2 for that. So now we're at a 27. And so now that finishes one part of the guidelines, and now we're asked to go to what's called Chapter 3. So you have Chapter 2, which applies there's many specific guidelines for specific types of offenses. And then you go to Chapter 3, which has a bunch of enhancements that generally apply to just about all types of offense conduct. such as the role in the offense or if obstruction occurred. Now, what's really interesting here, Rhodes was convicted partially. One of his offenses of conviction, as we know, is seditious conspiracy, but another one was obstruction of justice. He also ends up getting an enhancement of an additional 2 levels from a 27 to a 29 for obstruction
of justice.
And now somebody, for the guidelines people out there, lay people that might say, well, of course he should. But for the guidelines people, wait, hold on. He was convicted of obstruction. He's already been sentenced under the obstruction guideline. Doesn't all of his obstruction already take that into account? How can he get? Isn't this double counting, as we say in the field?
Yeah.
And the answer here is actually no, for a very specific reason. What happened with Rhodes is he engaged in additional obstructive conduct after his obstruction. So, without being so abstract, he organizes this militia to go and attack Congress, and they do that. So clear obstruction there. But then after the fact, he was involved in destroying evidence, telling individuals not to talk to the feds, and I can't remember all the specifics, but he was involved in additional obstructive conduct when the feds started investigating this conduct and destroying emails, obliterating evidence otherwise. So he gets hit with an additional obstruction enhancement for that separate conduct that occurred after his assault on the Capitol. So that's why and that's fine. You can get, if you're charged with obstruction, you can still get hit with an obstruction enhancement, and it's not double counting, provided that obstruction enhancement had to do with other conduct. So, and that's what happened here. This had to do with other conduct. So now he's at a 29, and now there's one other enhancement that he received, and this is the infamous role in the offense adjustment. And this generally occurs in conspiracies, and he was also convicted of a conspiracy. There are 3 different levels for the role in the offense enhancement. Basically, if you're a leader, you get a 4. If you're a manager, you get a 3. And if you're a supervisor, you get a 2. And he was found to be a leader. So that's an additional 4 levels, which brought him up to an offense level of 33. So now we're at 33, and a 33, that carries...
I have my handy dandy chart right here. A 33 offense, criminal history category 1, and of course the Zippo's not at issue here.
Right.
Is 135 to 168 months.
Right. That's correct. So now, by the way, you mentioned Zippo, and we just did a podcast on that. The Zippo would not apply here because the offense involved bodily harm, bodily injury, and stuff like that. So that's one of the criteria that would disqualify a defendant from receiving the Zippo. And Stewart Rhodes otherwise would qualify for it, if I understood. I don't think he has any criminal history, had 0 criminal history points. But at any rate. So now the big thing, what's really interesting about these cases, we spoke about them before, is this thing called the terrorism enhancement.
Yes.
And about 200 years ago, I used to work at the Sentencing Commission. Actually, I was there back in the late 1990s, early 2000s. I was there actually for 9/11. I was literally working in the commission on 9/11 when the planes hit the Pentagon. And the very next day, I think I spent all night there at the commission. Actually, no, I escaped. First, I escaped, make sure my wife was okay. Then I came back, I think, a day or 2 later when the commission opened back up, and we were all in shock. And we immediately created a terrorism team to start looking at this enhancement, which basically had never been used before. It was just sitting in the guidelines, and there had never really been an occasion to use it. The Congress, as we know, immediately created a very wide-ranging, huge legislative agenda around attacking terrorism. And one of the things that they did is ask the commission, hey, look at this terrorism enhancement. What should we do to it? Is there anything we need to modify it, and what have you? And it is a significant enhancement. As a matter of fact, it is the biggest enhancement in the guidelines. And it alone, what it calls for is, if it applies to you, you get a 12-level enhancement, which is almost unheard of.
Yeah.
As a matter of fact, I mean, there is no other enhancement. I mean, we have the loss enhancement and drug amount enhancement, and those can go up, like 30 levels and whatnot. But that's with more drugs or more loss or whatever. There is no one enhancement in the guidelines where just because a particular fact pattern may apply, you get 12 levels up. But it's even worse than that. Because with this enhancement, not only do you get, if you qualify for it, not only do you get a bump of 12, but your criminal history score actually moves from category 1 to 6. You have zero criminal history and no risk of recidivism and all that. But if the terrorism enhancement applies to you, you're getting a 6. You're treated basically as a career criminal.
Yeah.
So it's
off
very,
the
very
charts practically.
It's off the charts.
Oh, and by the way, you may not remember this, but we did a full-on podcast about this too, way back when. So episode 35 is called Trump the Terrorist ?
Yes,
Trump
thank you.
the Terrorist ? Because we're not we would never call the former president a terrorist, at least not unless he's convicted of something. But we did look, this was really focused simply on the terrorism enhancement and what would happen to him if he did get charged with some of these crimes, because the government's been very judicious in seeking the terrorism enhancement in the majority of these 1-6 cases, but they went for it in this one, didn't they?
Yes. Well, as a matter of fact, and I think we did speak about this, just about every defendant, certainly every defendant that has gone to trial has been faced with this enhancement, and every defendant that has pled guilty has had to agree to at least allow the government to argue for its application if the government so chose. And that's a hell of a concession. And I think some of the smarter ones didn't agree to that, and they ended up, pleading open and getting a much better sentence as a result. But that's something else. So just back to the to 3A1.4. So the one catch to this is, in order for it to apply to you, your offense conduct has to be politically oriented, politically motivated. You're aiming your offense conduct either at the government or a whole body of people to try to get them to change something. Of course, has to be politically oriented. But the other thing is, it has to be a certain statutory offense called a federal crime of terrorism. And there's only so many of those, and that's a federal crime of terrorism is itself defined by statute, and they're actually listed out, the different types of statutory crimes that can constitute a federal crime of terrorism. So if you're not if you did not commit one of those statutory offenses, even if your conduct was otherwise political and whatnot, politically motivated, you would not qualify for this enhancement. And that's one of the things that Congress had asked the commission when I was there to take a look at. What do we do in these situations? And we think they'll be unusual, and it'll probably never happen. But what would happen if somebody does commit a political offense here on American soil, and it's not a federal crime of terrorism otherwise defined? And so what the commission decided to do, and we on the terrorism team had recommended to the commission, is create an upward departure. And that's something in application note 4. And what application note 4 says, in essence, is if this is not strictly a federal crime of terrorism, and the enhancement doesn't apply because it's not one of those statutory offenses, but the motive was still there, this otherwise did constitute a political offense, or an offense aimed at some political end, then the court can, in its discretion, depart upward. And it's actually kind of an encouraged ground for an upward departure here. And so we noted that there in application note 4. Prior to January 6th, and I haven't done a bunch of research on it, but prior to January 6th, I'm not sure if that's ever applied in any case. Certainly none that I'm aware of. Maybe there may have been one or two outliers, but it certainly was never that particular application note. If it's been applied since 9/11, it's just been in a handful of times, and nothing of note that I can remember. And I'm pretty up to date on stuff like this.
So I think underlying this whole analysis, it maybe goes without saying, but none of the crimes of conviction for Mr. Rhodes were federal crimes of terrorism.
That's correct.
3A1.4 is not going to automatically apply, but the government is seeking an upward departure pursuant to the application note of how many levels do they want to kick it up? 12? Not 12.
Well, Well, they did, yeah, they didn't want 12, but they wanted 6. They thought it
Okay.
was half as bad, I guess. I'm not sure.
All right. 6
But
is no small potatoes if you're looking at the guidelines chart too. But
well, even
okay.
one, but I mean, even one is not any small potatoes. So the guideline, if you're at a 33, okay,
Yep.
and which is what Rhodes was at, the range is 135 to 168 months. Okay.
Yep.
Just going up one level, that goes from 135 to 168 to 151 to 188. So your
Yes.
upper range, the top of the
Yeah.
range, increases by almost 2 years, 20
Yeah.
months.
And so they want him
That's just one level.
They want him up 6 to a level 39, which is
Yes.
262 to 327. And
Right.
they're asking for 25 years, which falls within that range of two.
Correct. It's 300
262
months. Yeah.
Yes, 300 months. So they're asking for a
About
say
middle of the range.
mid-range sentence. That's very nice. At least they
Yeah,
didn't
very
ask
nice.
the high end.
Yeah.
So they want 25 years. And how this shakes out, ultimately, his guideline, the judge doesn't give him 6, but he gives 3, right?
About 3. Yeah. He departed upward by 3 levels. And this, again, is very important for people to understand, especially lay people, because there's been a lot of chatter since the sentencing came down, where folks out there, especially lay people, but even attorneys too, feel that the judge somehow gave him a break because the DOJ was asking for 25 years.
Yeah.
The DOJ isn't the entity that sets the sentencing standard.
Right.
That's the commission. And
Right.
here, the judge, both the judge and DOJ were already looking at sentences above the range. So this was already an unusual case. And by the way, I should add this: less than 3% of all cases nationwide receive upward departures in any given year. Less than 3%. So it's highly unusual to get an upward departure. Most cases end up with a downward departure or downward variance below the sentencing guideline, not above it.
Right.
So here we're already above it. So the point simply is this:
what'd you say? 3%? About 3%?
Less
than 3%.
Less than 3%
Wow.
get an upward departure. Correct.
Yeah. And I honestly cannot remember a case that I've had where I've gotten an upward departure.
Yeah.
So that tells you something. But you're right. The public perception is what? That he should have just been,
that he got a break. That he
should have been locked away, thrown away the key, life sentence, electric chair. I don't know what. But people who think 18 years in prison is a break, I don't think so.
Actually,
I've had clients who've murdered people who've gotten less time, but go ahead.
Well, that's hold that point. But
with their own 2 hands, by the way, not because people did die in January 6th. But anyway, go ahead.
But my point simply is that DOJ was already asking for an above guideline sentence at 25 years. The court came in less than what the government asked, but still more than what the guidelines recommended.
Yeah.
Even at 18 years, because that was 216 months. That's still significantly above. That's about over a 25% increase over the top of the range for what the guidelines recommended. So that was and most upward departures are only maybe a level or 2, or in terms of percentage, like around 10 to 12%. And this was double that, what the court did. So Rhodes did not get a break from this judge at all. Just the DOJ's ask was a bit too much. That's all what this is.
Yes,
what that 25 years represents.
And it must be noted that for every person out there who thinks that the judge gave a lenient sentence, there's probably another person who thinks that this guy got this was a grave injustice, and that he got a terribly long sentence, and that he shouldn't have been sentenced to anything because he's a patron. So nobody is good. That's kind of my point. Nobody's ever walks out of court happy about a sentence, I don't think. A defendant thinks they should have gotten less. A government should have gotten more, especially if you're the public and you have no real perspective on the system.
So Doug, can I share my screen then? Because I think we could give our viewers some some perspective here.
You should be able to do that.
Okay, so what I'm sharing here, this is from the Sentencing Commission's federal source book on federal sentencing statistics. They publish this every year. And this is table 27 for those who are listening. And it's a great table. I refer to it often. What this table shows you is what the average sentences are by offense type across criminal history categories. The reason why this is important, it can give you a sense, it provides some perspective on how serious or not a particular sentence is relative to other types of offenses. So he got a 216-month sentence. A lot of folks might think that, that wasn't just, that was too high or too low. What I like to do is look at, for really high sentences, is look at murder. If we look down here in offense level or criminal history category 1, the average sentence for murder was only 251 months, and the median was 216 months. And the median means half of those sentences were above 221 months, and the other half were below that 221 months. So at 216 months, it was nearly what somebody would get for murder. Yeah. So it's a very significant sentence.
And just call some of these other offenses out for people who can't see this. There's sexual abuse, which is 180 to 198. There's kidnapping, which is 120 to 1. These are like legitimate crimes of violence against a real live victim. Child pornography, 78 to 96. Assault, 4 to 40.
So, just on the child pornography right there, his sentence was over twice the average for child pornography offenses. And those arguably are the ugliest of all federal offenses.
Robbery, 65 to 81.
Yeah. This chart is very, very helpful to put it in perspective, regardless of where you are in terms of the justness of a particular sentence. Looking at this chart at least gives, and I encourage everybody to do it, and especially in their sentencing presentations, is to show a judge, where a sentence is coming down. A judge might think 70 months for whatever reason in the grand scheme of things is not a very significant sentence. But then once you tell him or her that, it's the median sentence for robbery is only 65 months, that might change things. And maybe that is a little too high or not high enough or what have you.
Yes. And as far as we know, that these, like I said, this broad sweep, this big bird's eye view could have really animated the judge's final sentencing. That and looking at all the other 1-6 defendants, and
correct.
So this is a sentence that makes a lot of sense if you look at the big picture.
And then,
but of course, most people don't have the big picture.
Right.
Here we are. That's why we're here.
That's why we're here. So just one last quick one before we move off the topic. But this is the good old handy dandy life expectancy chart that I like to
we
do.
Talk about this all the time.
Yes.
Defense lawyers need to argue this. Of course, they didn't hear. But life expectancy for those incarcerated is far less. So Mark does these cool charts. You can't see it if you're not on the YouTubes, but he's going to tell you what these numbers are right now.
So what I do is I take the defendant's sentence at the time he or her were first committed. Now, Rhodes was committed back in 2022 prior to sentencing. He was first incarcerated or remanded, if you will, back in 2022, awaiting trial and then sentencing, unlike many other defendants who they remain out on bond through trial, through sentencing, and then they're allowed to self-report. But anyway, the point is, I'm getting too much in the weeds here. So I look at the defendant's age at the time they first reported and were first remanded into custody, and then see what their life expectancy was at that time. So back in 2022, Rhodes was 57.6 years old when he first was remanded into custody. According to the Social Security Administration, at that time, his life expectancy was 82.7 years. Now, what we know is incarceration is not ideal for the soul or the body.
Yeah.
And a professor back in 2013 named Elizabeth Patterson did a study that was published in peer reviewed and published in a journal about the effects of the effect of long-term incarceration on an inmate's life expectancy. And what she found was that on average, inmates can expect to lose 2 years of their life expectancy for every year they are incarcerated. And of course, that makes sense, especially, within the Bureau of Prisons and what a dismal place it is. The healthcare is very poor. The being in those surroundings lead to depression and lack of stress. It's just illness. Not right, exactly. And it's a great place for to get sick.
Yes, well, we've done plenty of podcasts on that too. But people, we talk about this a lot. But for those of you who haven't heard us talk about it, what we're saying to you is, in all cases, life expectancy, well, not all cases, but if you have somebody probably 40, 50 years old and above, you should be looking at this. But also, we've been doing it wrong because people don't know about the Patterson study. And we've just been using the Social Security actuarial tables. Those are for non-incarcerated individuals, and they don't apply in this situation. So take a look at life expectancy and make sure you do it the right way, which is Patterson study. And if you need help with that, hit markup. Go to sentencingstats.com. Anyway, go ahead.
Okay, so looking at that, 82.7-year life expectancy, and he's 57.6. If he's going to lose 2 years of life expectancy for every year that he's going to be in, what this chart shows you is he's not going to survive 7 years on average in custody. And especially for somebody of his high, and it's probably worse than this because of his notoriety. He most likely is going to be at a higher security, and we'll talk about this more, but he's going to be at a higher security institution than somebody else would have that was not as notorious as he. And he may end up spending a considerable amount of time in solitary confinement or the special housing unit for his own protection and protective custody, because there's going to be a lot of people that aren't going to be a fan of his in prison. But at any rate,
and we don't know how healthy this dude is to begin with. He doesn't look to me to be like a pillar of
exactly. And this has been very stressful.
We have no idea.
But 7. So I mean, here's the point. Whether he received a 25-year sentence, a 50-year sentence, or an 18-year sentence, any sentence appreciably over 7 years is going to be a de facto life sentence for this guy. So he did not get he certainly did not get a break. Although it was interesting to hear, according to at least one reporter speaking to his defense counsel immediately after sentencing, they were surprised that the judge was as lenient, I think is what their term was, as he was. But at the end of the day, he was not lenient just because he didn't go with what the DOJ was recommending.
Nice. Yep. All right. So there you have it. Let's talk about sentencing advocacy. Now, I would say, we've done this before. We've done it in Holmes and Bolwani and Avenatti and the Chrisleys. And I do think it's a very, very valuable exercise to see how the lawyers are doing representing their respective clients. So we're going to focus on the two sides, just Rhodes's attorneys and the sentencing memo that they filed, and then the government's memo. I want to see what kind of advocacy are they engaging in their written work, because these sentencing memos, we do them in almost every single case, and they can be very effective if done right, or they can be a big old giant fucking waste of paper if they're done wrong. And I hate to say it, but a lot of lawyers do them very wrong. And I think this case is a quintessential example of that. So we're not going to just talk about the memos, but there's the whole giant thing of sentencing advocacy. And I will give the defense lawyers, a little bit of an out here, which is to say they had a monumental task going into sentencing after losing a trial and having zero remorse, really doubling, tripling down on the idea that I'm a patriot and, whatever it is. So what do you do with that as a defense lawyer? And we have all had those situations where someone's gone to trial, they've lost, and they can't then fall on their sword and say, I'm so desperately sorry for what I've done. I've learned the error of my ways. So what do you do with that? Now, I will say, for me, it all goes back to the 3 R's of sentencing narrative, which is, I think all stories and you've heard me talk about this ad nauseum, and you have an article, I'll put it in the show notes. It's free. Go download it. 3 R's: revelation, relativity, and redemption. Now, revelation are these things that reveal sort of a deeper truth, the story behind the story about how a client ends up in the mess that they're in. How did they get to this moment in time? And it's not there to necessarily, not at all, to excuse the conduct, but to kind of explain it and give the judge a better context for how a person might be led astray and, fall prey to whatever mistakes and choices they might have made. And that's just not happening here. There's no way that I can see. There's no path forward for a revelation story for these defense lawyers. So I don't fault them for not telling that story, because their client most likely wouldn't let them tell that story and wouldn't give them any good fodder for them to tell that story. So how he gets into this mess is he's been the head of OathKeepers for a long, long time, and he's a zealot and he's passionate, and this is what he wants to do. Okay. So what are you left with? The next one are what we call relativity, where we compare this to that. And the lawyers tried to do this and failed utterly. And what they tried to do is compare this 1-6 defendant to the many 1-6 defendants who have pled guilty or been convicted at trial, have gotten very relatively small sentences, to say, hey, look at all these 1-6 cases. You should give a sentence more like those guys, not anything crazy like 25 years like the government. And if you look at their sentencing memo, it's 70 pages if you go download it from the docket. But in truth, the memo part is 15 pages. And the rest is an attachment. It's from page 17 to 70 is an attachment of all the sentences handed down on January 6th cases up until April 7th. So they're doing a giant relativity play in here. And it really just falls flat, because the government says, this is not your run-of-the-mill 1-6 case. This is the worst of the worst. And you need to treat it like that. So I guess, go ahead.
Sorry to interrupt, but most of those sentences, and I know where they got their chart here. This is from the Department of Justice, has a running total, if you will, of all J6 cases and defendants, and this is basically a cut and paste from DOJ's website. Most of these individuals, you could just see what the sentences they received. There were most of them were misdemeanors. So this is not helpful in the least. If anything, when you use bad data, you just highlight the seriousness of your client's conduct. And what I think what all they did here is help dig a hole and help justify a very different sentence for Rhodes, given the conduct of these other individuals and what sentences they received, because they were minor players. They were the minions, if you will, as opposed to the leaders or the leadership. And and I think a better route, at least for me, I would have suggested, is looking at if you didn't have a redemption story, which you didn't here, but if you needed some good data, life expectancy, as well as looking at other serious types of offenses and seeing what kind of,
like that chart we just pulled up earlier.
Exactly, like that chart. I mean, because he could have gotten under 10 years or less, with some of that other stuff. Okay, sorry.
And I'm reading now from the government's reply on this issue, and they say, literally, quote, this is not a, quote, January 6th case, end quote. So it is kind of, but they're saying this is just not even. As my torts professor, Charles McManus, liked to say, you're in the right church, but the wrong pew. And I don't even know if this is the right church. I think there's down the road at somewhere else. Anyway, the defendants ought to serve lengthy terms, the government says, of incarceration because of their participation in a month-long conspiracy that aimed to oppose by force the authority of the United States. So these aren't the unwashed masses who got swept up in the moment the day of and end up at the Capitol. This is a lot of planning and a lot of serious talk about overthrowing the government. So sorry, no go on that. And here's the other maybe I read a little too much into language, but the next paragraph starts out like this. Similarly, why can't I say that word? The fact that certain individuals have not yet been charged as part of this conspiracy does not in any way minimize the culpability of these defendants. And what were they saying in these cases? Like, we thought we had our marching orders from on high.
Right. Exactly.
We were just
Hint.
following orders, and they say yet. Why is that word yet in there? What does that mean? Maybe nothing. Maybe nothing.
Yeah.
So okay, so we did Revelation, we did Relativity, and let's talk redemption. Now you say he doesn't have a redemption story. I say they tried very desperately to make this sentencing memo about Elmer Stewart Rhodes, and more importantly, the OathKeeper organization's
Mm-hmm.
redemption story. They really went to great lengths to tell a story about the OathKeepers that is really just about an organization that customarily engaged in community service. They talk about how they respond to Hurricane Katrina and Hurricane Harvey, and they're there to protect people and disaster relief efforts and voluntary security for speakers at public and large and sometimes violent venues like Berkeley, those liberal fuckers in Berkeley and Dallas and Ferguson and DC. So they literally said his service and his actions over 13 years that he headed the OathKeepers, quote, go above and beyond what is customarily considered community good works.
Well, can I respectfully disagree with you?
Well, I'm holding in my laughter because this sounds on its face patently fucking absurd, but yeah, go ahead. Go ahead.
Okay, this is just, well, I don't know if this is valid criticism or not, but in terms of the redemption story, yes, they do try, but they spend the first half of the sentencing memo talking about things such as Booker.
Oh God, yes.
And copy and pasting the entire statute 3553A and putting it in there. For what reason, I don't know.
Oh, absolutely.
And they waste the first half of the sentencing memo is completely wasted when that could have been used for the redemption story. They only spend 4 pages of their memo on the redemption story and all these good works that the OathKeepers do.
Right.
But there's no visual, there's no pictures, and they're not citing to any exhibits. It's just yes. It's kind of a boring narrative, and so it's not a very good impactful presentation. I'm sorry.
1,000% agree with you, and I was definitely going to point that out because we rail on these defense memos all the time that you put even an ounce of boilerplate in there about hey, judge, the guidelines are discretionary. The judge knows that.
Yes,
move on, dude.
No boilerplate anymore, please.
I would love to go through this because it wasn't just the first half, Mark. It was littered. It was like scattered all through these 15 pages. To where I think if I distilled these 15 pages down to actual substantive, I want to say argument, but it's barely argument that's specific to this client, it's probably is 4 or 5 pages.
Yeah, exactly.
Of something, and a lot of it was redundant. Most of it was redundant. But and then you raise so it's just wasted space. It's a joke. Yeah. And then you raise a great point about pictures or back it up with something like, all right, listen, I didn't know the OathKeepers did all this great humanitarian relief efforts and hurricanes and everything else. So if that's true, I need to see that. And do you have one photo you could throw in that memo of Elmer handing out bottles of water in the community when people are, needing a lifeline during a hurricane? Do you have a person like, how about, were there any sentencing? I don't even know if there were sentencing letters submitted. Now, I'm not a huge fan of necessarily of sentencing letters, but you need somebody somewhere to say, to come in and say, yeah, I know that OathKeepers, this is bad, but that's not the whole story here. You're trying to define this dude by his worst moments on this day with this organization, but the truth is, this organization, that wasn't why they came into existence, and it doesn't represent the majority of the work that they do in the world. And this is not good, but they have done a lot of positive things in
Mhm.
life. And this man in general has done a lot of positive things in life. So let's look at those. And at this point in time, that's all you fucking got.
Yeah.
We're not here to argue about whether he's a patriot and whether he's a political prisoner and all that stuff. It's going to get you nowhere. Now,
Right.
I'm guessing they tried to convince Elmer of that before he opened his mouth at sentencing, but clients are going to client. Like
Yeah.
you can't control what they're going to do or say, and I'm sure they weren't happy about that.
Yeah.
But they needed to control the narrative and own the story and say, Judge, we're not going to talk about any of that. Now we're going to talk about who is this man at his core. What is his character? And maybe they didn't, maybe they tried, maybe they couldn't find anything. Because I got to tell you, I did some research on Elmer Stewart Rhodes, and
Yeah.
I saw his wife on ex-wife now on
Oh, yeah.
CNN. Do you know what she said after this? What was her response to this
Thank God.
conviction? Yeah. She literally said, "We are very happy." She
Yeah.
said, "It has been a great week for us as a family.
Mm.
We're happy to feel safe. We're happy he's in a place he can't hurt us and
Mhm.
can't hurt anybody else."
Yeah. Yeah.
And when asked, do you think he's learned his lesson or he's going to keep advocating for all this stuff? She said, "This is his life's work. He'll
Yeah.
regroup and he'll do it again until he creates the kind of chaos he wants to create."
Yeah.
So granted, she's an ex, but even his own kids were like, "Oh yeah, no, this
Well,
guy's the worst."
well, he said as much during his allocution, so that's not surprising at all. He
Uh-huh.
he really revealed. Well, I don't think he revealed himself so much as confirmed himself for everybody. But see, that raises, I think, what's really interesting about this case is how do you represent the impossible client? What can you do at sentencing if you have somebody like that's so recalcitrant, that's incorrigible,
Yeah.
literally incorrigible? What do you do? And you can't shut him up. He's gonna exercise his right to dig a hole. He wants to get up there and do an allocution. The only
Yeah.
thing you can do, I think, and it's something that should be done in every case, but especially in the incorrigible ones, is data. Look at the numbers, look at the sentence, and not just to compare and contrast and all that stuff, but to give the court context. You're going to impose a significant sentence, Your Honor. You're very angry at this person, and justifiably so. Look at him, listen to him, all this other stuff. But don't don't allow judges to give away months like they are candy. And I think that is the biggest problem that has resulted from the sentencing guidelines since their inception. We are so, and judges too, they're human. We are so attuned and so adjusted to giving away 50 months, 10 years, 15 years. It doesn't really start to sound serious until you're talking about 30 years.
Mm-hmm.
But 30, 40, 50 years ago, a 30-year sentence was a life sentence, and only the most incorrigible murderers got something like that. And
Yeah.
as a society, I think our filters have changed so much that judges have no problem giving away months without fully understanding what that means in context, especially relative to other types of offenses. And so obviously you're going to get into comparing and contrasting, but I think that's all you can do here. And I think that's what's, if you will, forgive me for saying it this way, but the beauty about this case is it really shines a light on the most important aspect of advocacy at sentencing, and that's coming up with data as opposed to the old-fashioned way, Judge, give my guy a break, because that's never going to work. And that's essentially what they're trying to do here.
And I will say, I think that's true. If you always have that, I think is the point.
Right.
You always have the data,
and that's sometimes that's all you have.
Yes.
And that's my point here with
Yes.
Rhodes, is that's all they had, and they blew it.
They blew it. But they did try to fake their way through a redemption thing. And my takeaway on that is, if you're gonna do it, prove it. Show me.
Yeah,
Don't say it, because it seems silly on its face, and it may not be silly. The
right.
Oath Keepers may have done a lot of good things in the world, and that is the time to tell that story. And
Well, the government had pictures, had color pictures in their
oh,
sentencing
they
memorandum.
sure did. They sure did. And so yeah, so they understand there's a value of that. And the only other thing that they raised in the well, they asked for acceptance of responsibility, which was rich. But we won't have to spend a lot of time on that.
Yeah.
But they raised his military record. And the government kind of pointed out, yeah, he did spend some time in the military. He washed out apparently because he couldn't learn Morse code, and he never got any commendations. It was a very unremarkable military career. And by the way, the argument could be made that that was just training for everything that
Yeah.
came later that is the problem in the case. So to me, also a waste of space and a
Right.
waste of paper. And if you're going to tell a story about military service, you better tell me a little bit more about why, just the fact that you enlisted and went into the military. I don't know if that's going to get you very far in this day and age. Now, there's probably a story about him that couldn't be told, whether it's traumatic stress, whether it's an abusive childhood, whether it's mental health, whether it's, I don't know, autism spectrum, depression, anxiety, paranoia. Something's wrong with him because, well, arguably, what do I know? But I'm just saying, like, his family describes him in a bunker for the last 15 years, like literally digging himself into holes and eating rations for his family, like thinking the apocalypse is coming. Like, there's a whole other story here. And again, in deference to defense lawyers, probably they just couldn't tell it.
Mhm.
But there's something else going on here. But I guess the takeaway is there's always something you can do. And in this case, they missed even the smallest opportunities to move the needle even a little bit. And guess what?
Yeah.
Even a little bit matters, right?
Well, even a little bit matters a lot. And this is also a rare case, too, because what we spoke about earlier with an upward departure. I mean, those, if anything else, if nothing, if nothing else, they should have fought that. Judge, give him the upper, give
Yeah.
him, instead of the bottom of the range, give him the top of the range.
Yeah.
But the guidelines got it right. The commission got it right. The government's always talking about how the commission gets it right, and da da da. And here they did. And this is a serious offense. It is offense level 33. There's no reason to depart. This is not just because an offense like this doesn't happen very frequently, doesn't ipso facto make it outside of the heartland and all this stuff. They should have fought that upward departure, because the government sure as hell spent some significant time on arguing why it was warranted in this case.
Yeah.
And they actually, I'm looking at page 70 of the government sentencing memo, where they spend some time and they note, look, it's been asked for, and we've asked for it, and hasn't been applied in several cases, and judges have declined. But this is a case.
If not now, when?
Yeah, exactly.
Yeah.
Exactly. And but citing that same data, the Rhodes counsel could have said, look, Judge, it's not being applied. The government keeps asking for it. That's not the purpose of this particular enhancement. These are not domestic terrorists. Don't make them into something. At least give that argument. And this would have been a perfect opportunity for that. If nothing else, they should have argued against an upward departure, because just looking at that again, they could have saved him. And again, and just remember, before everybody gets angry at me,
people are going to get angry at us
I know.
what,
Allenbaugh, da, da, da.
You're a defense lawyer.
I know. They could have, he saved him some significant time, but he's still going to die in prison, because anything over 7 years, just remember that he's going to die in prison. But if he to go from a 30, what did I say? He was at a 36, and he got 216. Down to a 33 in the middle of the range, he would have been looking at around 150 months. So that's could have saved him 5 years. There's 5 years right there in that upward departure that they spent zero ink on.
Yeah.
I'm sorry, that frustrates the hell out of me because that's not
Well,
good advocacy.
I agree 1,000%. And let's wrap this part of this up with the ink,
Yeah.
because I do just want, I think it's instructive to look at the first, right out of the gate on these sentencing memos. You want to open hot. And we already
Mhm.
talked about how much wasted space with boilerplate, but just look at how the defense comes out and how the government comes out. I'm going to read you the first 3 lines of this. Come now, James Lee Bright, Philip Linder, and Edward Tarpley, quote, counsel, end quote, for Elmer Stewart Rhodes, hereinafter, quote, Rhodes, end quote, in the above reference cause number, and file this sentencing memorandum for the court's consideration for sentencing. Why did you think they put counsel in quotes? Are they not real lawyers? Maybe not. Maybe we've solved the mystery.
There you go.
Okay, so now that's the first paragraph. So
Yeah.
that's how you come out hot in a sentencing memo? I don't think so. So maybe they're going to redeem themselves in the second paragraph. What do you think? Counsel received the PSR, which is our lingo for pre-sentence report, from the court-assigned probation officer, Ms. Crystal Lustig, hereinafter, quote, PO, end quote, on March 24th, 2023. As mentioned in our earlier filed objections, bleep, blop, bleep, blop, blop, reads similar to opening statements made by Mr. Nessler in the Rhodes trial. Counsel objected to the majority defense conduct on pages 23.
Yeah.
And then we go into sentencing post Blakely and Booker. We need to educate you, Judge, on what the state of the law has been for the last almost 20 years.
Yeah.
So we don't get to any
And Blakely, I forgot that you mentioned Blakely.
Blakely.
Like, nothing to do with federal sentencing.
And we got Rita and Gall and Kimbrough, and it's we already talked about how long it takes them to get to the fucking point.
Yeah.
But starting out with that boilerplate just is a signal you're in for a real treat here, folks. We're about to bore you to the point that you wish you were dead.
Yeah.
Okay, so now I'm gonna share. We're gonna do the same thing, and I guess in my bones it pains me to give kudos and props to the government, but hey, credit where credit is due. When you do a good job, I'm going to tell you about it. And let's compare the very first paragraph that we just start to this one. These defendants were prepared to fight, not for their country, but against it.
Yeah.
In their own words, they were, quote, willing to die, end quote, in a, quote, guerrilla war, end quote, to achieve their goal of halting the transfer of power after the 2020 presidential election.
I mean, you can hear that in Morgan Freeman voice. That's written so well.
And the last sentence is, as a co-conspirator recognized, their actions made these defendants, quote, traitors.
Yeah.
End quote.
That's a grab. That's a big grab.
Yeah. So the quote, they both are using quotes. In theirs, it's counsel and it's Rhodes and it's offense conduct and it's PO. Those were the quotes versus willing to die, guerrilla war, and traitor. Now, I'll read the second paragraph too, just because, they don't just stop hot. They keep going and they turn up the heat, which is using their positions of prominence within an affiliation with the OathKeepers organization. These defendants played a central and damning role in opposing by force the government of the United States, breaking the solemn oath many of them swore as members of the United States Armed Forces. To support their operation, they amassed an arsenal of firearms across the Potomac River and led a conspiracy that culminated in a mob's attack on the United States Capitol while our elected representatives met in a joint session of Congress. 2 juries found all 9 defendants guilty of participating in this grave conduct. These defendants are unlike any of the hundreds of others who have been sentenced for their roles in the attack on the Capitol. Each defendant, therefore, deserves a significant sentence of incarceration. So not only is it a powerful use of language and powerful storytelling, but it's a very, very good roadmap for their entire 183-page brief that they're filing.
Yeah.
In
Yeah.
other words, you could have stopped there and you would have known exactly not only every argument they were making, but they shot down every argument that
Right.
Elmer was making about military service and sentence me like the others. And the
Yeah.
OathKeepers are good, our Boy Scouts, you know,
Yeah.
who are on their way to the bingo parlor at the YMCA, you know, that whole thing. They just killed it
Yeah.
in 10 lines.
Yeah.
That is
Yeah.
the way you open a sentencing memo, people.
Mm-hmm.
That is the way you do
Agreed.
it. Okay. So we have one last thing to talk about, which is prison. I guess one of the big questions people always ask is, okay, the judge sentenced him to 18 years. How much time is he really going to do? Especially now that Governor Pudding Hands, what's his name? Dick Santis is saying, I'm going to repeal the First Step Act. If I get in that's what he wants to do. And the First Step Act gives people the opportunity to redeem themselves by participating in positive programming to better themselves.
Mm-hmm.
People do change in prison. Elmer might see the light in the course of these next decade or so. And isn't everybody worthy of a shot of redemption? So we reached out to our go-to prison consultant people, which is our great friend, former BOP warden Maureen Baird, and her colleague Walt Pablo, who runs prisonology.com.
Yeah.
And we've done podcasts on prison consultants before. There are some good ones and there are some maybe not so good ones, dare I say shady ones. These are the good ones. And whenever we kind of want to know, like, where might they go? How much time will they do?
Mm-hmm.
What's that time going to look like? We go to them and they give us the straight skinny. So let's talk about that real quick. So Walt sent me sort of a calculation of how much time does he get, how much credit, how much time has he served pretrial custody, how much everybody earns good time credit if they behave of 54 days a year. So you're going to knock that off of 18 every year if he's good. And then there actually is a potential for him to earn First Step Act credits, even though some offenses are excluded because of the nature of the offense. You can't earn these extra credits, good conduct credits, times, what do you call them? FSA credits?
FSA or ETC credits, earned time credits.
Earned time credits. Yeah. Here's what Walt Pablo says. He was arrested in January 22. He'll get jail credit for that. He was sentenced on May 26th. I think it was the 25th, but whatever. He'll get 498 days of jail credit for that pretrial incarceration. He won't start earning FSA credits until he's at the designated institution. And for those who don't know what that means, he's been in a pretrial facility through the trial process. Eventually, BOP will pick an institution for him to begin serving his actual sentence. We don't know where that will be yet. But once that happens, he'll start earning some of those FSA credits. He estimates that'll be maybe August. He said based on that, he'll get 365 days off his sentence, making his FSA outdate September 25th, 2037. As he keeps earning credits, he'll earn 1,555 days of FSA credits toward pre-release custody, halfway house, or home confinement. He can apply those credits on June 23rd, 2033, when he has approximately 1,555 days remaining in his sentence. He will apply the credits and head to a halfway house, then, at some point, home confinement. In total, he'll spend 52 months in pre-release custody and get a year off his sentence and 972 days of good conduct time. So it sounds like he's going to be out of custody in 10 years. If it says he could apply those credits on June 23rd, 2033. Yeah. And by out of custody, we mean out of a prison, but he'll be either at a halfway house or home confinement to finish his time. Right. But he could be out of prison in 10 years is what I'm reading here. Does that make sense?
Yeah, that makes sense. I calculated it maybe a little bit more liberally than Walt, and he's the expert. But I have him out in about 8 years.
Okay.
But I'm sure I'm over calculating something. But whether it's 8 or 10 years, going back to the Patterson study, and before everybody gets upset and wants to repeal the First Step Act, it may not be all helpful to
Yeah, if
Mr.
they
Rhodes
weren't
here.
pissed, if they were pissed at 18, boy, oh
Yeah.
boy, how
Yeah.
pissed are people going to be when they hear 8 to 10? But go ahead.
And by the way, we should make a big caveat here with respect to the First Step Act credits. He has to successfully, like anybody, will have to successfully complete these programs
Yeah.
in order to qualify for them. And these are assuming that he would take maximum advantage of all the programs offered to him and successfully complete them. Something tells me, and also not get in trouble.
Yeah.
He can't have any, write-ups or, and all this other stuff. Something tells me that's going to be very difficult for Mr. Rhodes to do. So
Yeah.
this is all highly theoretical. And even if he was able to get all these credits, it's still beyond his life expectancy in prison. So everyone calm down. He's not
Yeah.
going anywhere.
Right. Right.
Yeah.
And then so maybe this will make people who want to see him punished severely a little happier. Because
Yeah.
I asked Maureen, what do you think his time's going to be? Because people have this image of federal prison sometimes as the country club, the camp, the this, the that. And, so where's he going to go? Is he going to go to a camp, a minimum, medium, maximum? Like, what's it going to be? And the truth is, nobody knows. By the
Mhm.
way, the truth with FSA is kind of nobody knows
Right.
either.
Yeah.
It's so brand new that even BOP doesn't know how to calculate FSA. So if you sense a certain amount of ambiguity, uncertainty in our calculation, just know that that's the state of affairs with First Step Act. But anyway, where's he going to go? Nobody's going to know. He has no criminal history and all that other stuff, but I'm real curious to know because according to the judge and the government, this is a domestic terrorist. And
Mhm.
I think about when we had 9/11 and Islamic extremist terrorism, where do those folks go?
Right.
And those folks, where do you remember? Like, you know,
Guantanamo.
yeah, well, a lot of them went to Guantanamo, but the ones that went into the BOP, some went to the Supermax in
Yeah.
Florence. The idea
Yeah,
was
Rex. Yeah.
the idea was if they're in the general population, they're dangerous.
Right.
If they have access to the outside world, phones, media, they're dangerous because
Mhm.
they're spreading not only their ideology, but they're allowed to plot and plan their stated goals of using force and violence against the United States. And so I really have to wonder what the security classification is going to be for him. If he was an average Joe, he'd probably be in a low or a medium facility. It wouldn't be
Mhm.
that bad. But if the BOP, and this is what Maureen says,
Mhm.
thinks it's necessary, they're going to apply a greater security management variable.
Yep.
And, he could be isolated. And if you look at the government sentencing memo, they say, quote, upon release, basically they're painting him as unrepentant and an ongoing danger. And they say
Mhm.
upon release and potentially even while incarcerated, Rhodes will likely continue to organize his followers to forcibly oppose the government and the laws of the United States. And some of those 9/11 folks didn't barely had access to their lawyers, and one of their lawyers even got in trouble because she was violating some protocol of communicating with passing along messages from her
Mhm.
client to the outside world. So this guy could be in for a wild ride. And the other aspect that Maureen points out is he may spend, and you said this earlier, he may end up spending a lot of time in solitary confinement. Why?
Protective custody to protect him from other inmates because of his notoriety. He's going to be a big target for folks. Especially if he ends up at a medium or a high. There's not going to be a lot of fans of his there at these places.
And I wonder because I pictured this as sort of a white supremacist thing, although they would deny that, and they did deny it in their pleadings. So that means half the population will be his pal and the other half will be his enemy. But that's kind of the way life works inside prison a lot of times anyway. You kind of you pair off with your groups so that you're protected. But I don't know.
Yeah.
The other thing that might end him up in the shoe is if he misbehaves. If he
Right.
does continue his bad behavior in there, he'll spend a lot of time thinking about it, his choices, all alone in the shoe.
He's not going to have an easy time. That's for sure.
It's not. And guess what? No prison is easy time. I don't.
Yeah.
And it still even bugs me when they go, they went to a camp. They went to a minimum security. Okay, that's easier than a maximum security. It may be safer, but it's still prison, dude. And unless you've been there, don't talk about it. And that goes back to what you said about the judges handing out months like candy and prosecutors asking for these exorbitant sentences. I wish every single one of those people would spend at least a day inside the walls of a prison so they can get even just a little sliver of the experience of what it's like to have every moment of your day micromanaged, to not be able to wear the kind of clothes that you want to wear, eat the kind of food you want to eat, to not be able to have a contact visit with your mom, to not have any visits because a pandemic is raging, to have to worry about somebody hurting you physically or sexually, to have your entire life on hold while the rest of your friends and family and lovers go on with life without you.
And it's going to be overcrowded too. Most likely the facility he's going to end up at is overcrowded or close to being overcrowded. And as the Inspector General just released a report, I think about a week or two ago, about the abysmal infrastructure in the BOP. And, wherever they're at, there's ceilings falling in and bugs and rats and things like that everywhere. It's very inhumane. And nobody says that prison should be, of course, like a club fed, as some have referred to it in the past. It certainly isn't that way, and it's getting far worse.
It sure is.
Yeah.
With no change in sight from what I can see. So
correct. Yeah.
Stay tuned. We have more of these defendants, even in this trial, getting sentenced, but we're going to do another podcast soon. We're going to keep on with these 1-6 because there really are a lot of interesting cases that shine a light on federal sentencing. So we'll be talking again soon, man. Thank you so much.
Thanks a lot, Doug. I appreciate it.
That's it for today. But before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.